各位早晨。
Good morning, members. We've formed the quorum, and it's the appointed time, so I declare the meeting open. Item 1 is confirmation of the minutes of the last meeting. The last meeting's minutes have been circulated to members, and the Secretariat has not received any proposed amendments. So I will invite members to confirm the minutes of the last meeting. Okay, confirmed. Next, perhaps we'll invite the administration team to join us. I believe you have received the papers tabled in front of us. It's an updated version of the paper, and that has to do with the wordings of the amendments. And this paper will replace the version dated the 13th of July. Welcome, Andy, and other government officials from different departments. Perhaps, Andy, if needed be, please take us through your response to our questions raised at the meeting on the 29th of June. I think you have received the paper. So, Andy, please take us through the paper. Thank you, Chairman. Good morning, Chairman and members. This past Monday, 3 days ago, we submitted a paper in response to the issues raised by members in the last meeting. And the paper number is CB41288. The chairman has said that earlier on, in fact, this morning, we have updated the annex of that paper. Well, actually, we stated last set that it is a preliminary draft only. And that annex sets out the amendments proposed in response to member suggestions. So we submitted the preliminary draft to members earlier, and at the same time, we carefully went through it once again and make it more detailed. The meaning is the same. We're just improving on the wordings. Actually, the meaning is the same, but the wordings are more detailed. So that's the only difference. So can I suggest this, Chairman, because the annex is the most crucial. And actually, in the last meeting, we finished the clause-by-clause scrutiny, and members have raised very useful suggestions, and we've promised to consider them. So in the form of an annex, we have responded to members' suggestions on how the amendments should be made. So I would defer to the law draftsmen to take you through the considerations for the amendments. So I will set out the principles here. There are two policy issues involved. One, we've said all along that we've proposed a mandatory lease requirement. That would be the last resort. Members said that since it is the last resort, so can we make it clear in the draft bill? In other words, if the new operator and the existing operator can reach an agreement under market principles and make certain lease arrangements, so there is no need for the government to interfere. So if our policy is that clear, so why don't we write it down? So that's what we've done. We've written it down in the bill as well. Second, Mr. Sim mentioned that if the existing operator would like to have his right renewed, it would have to raise it 3 years beforehand. So how long will it take for the government to consider its application? There should be a time limit set down, or a well, to make it clear that the government should consider it in a certain period of time. So we've also built that in. So I'll defer to the law draftsmen to take us through the exact wordings. Gilbert, please. The Deputy Secretary has already talked about the amendments related to the two policy issues discussed. I refer to the Blue Bill. We will be dealing with Clause 6 first. And then has to do with the addition of 2C. And we would like to add in a subsection 3 that Chief Executive in Council must determine an application for the operating right without unreasonable delay. So that would make sure that the Chief Executive in Council has a statutory duty to deal with the application for the operating right without unreasonable delay and make a decision accordingly. Chairman, the second amendment has to do with the wordings, and that has to do with Clause 13 in the bill. And we suggest adding in 8A to E, and in 8, capital letter A, the wordings is that if the company fails to operate and maintain the tramway properly, and in the Chinese word, maintain is translated as 维持. And because there is a substantial breakdown causing injury and so on, so in the Chinese version, should it be 维修保養 instead of 維持? So after considering this, we think this is a good suggestion. So we propose to replace 維持 with 維修保養. And the third amendment has to do with Clause 15. There is a proposed section of 11B, and that has to do with mandatory lease of essential premises and mandatory sale of essential equipment. We propose to add in, well, the subsection 1 says that the Chief Executive in Council may order the person lessor who owns any essential premises to lease the premises to a party lessee designated by the Chief Executive in Council. In the last meeting, some members said they hope that this will only be a last resort, and that is if the existing operator and the new operator cannot reach an agreement, then that last resort will be invoked. So that's why we propose this new section, and that is the power under subsection 1 must not be exercised unless the Chief Executive in Council is satisfied that there is a substantial risk that the operation of the tramway will be disrupted if the power is not exercised. If that is not the case, the power cannot be invoked. So this reflects the Policy Bureau's drafting instructions. We want to make sure that there is a precondition before this power is invoked, and that is if this power is not invoked, then there will be a disruption or a risk of the disruption of service of the tramway. I've read through the amendments, and they are made in response to members' suggestions in the last meeting. And Assistant Legal Advisor, on the amendments, do you have any questions or comments? Thank you, Chairman. I've read through the latest version of the amendments proposed by the administration. I hope that the administration can, in relation to Clause 15, can elaborate on it. There is a scenario that I would like to find out more about is what is the legal effect of this scenario. The way it is now worded is that unless the Chief Executive in Council is satisfied that there is a substantial risk that the operation of the tramway will be disrupted if the power is not exercised, then the power under subsection 1 must not be exercised. I understand this, and I'm sure that members also understand this, but there is this scenario that I'm thinking about. If the tramway or any operator in the middle of the right or the license would like to exit and don't want to continue with this service, and then it tries to negotiate with party A to hand over the right to this party A, and they would do it by commercial principles. And the negotiation may take a long time, and before an agreement is reached, will that be the case that the Chief Executive in Council thinks that even if the negotiation is going on, then there may be a substantial risk that the operation of the tramway will be disrupted. So the Chief Executive in Council exercises the right to appoint or ask Party B to take on the operation. But then ultimately, later on, the company, the existing operator, can reach an agreement with Party A and pass on the right to Party A. Now, if the Chief Executive in Council has granted the right to Party B, then what will happen? Will that kind of scenario happen? Will that be a case that there is a party favored by the existing operator, but there is another party which has been granted the right by the Chief Executive in Council, which is another party, Party B? So will that happen? Perhaps I'm not very familiar with the operations of the tramway company. So anyway, I have this question for you. Well, let me share my views with you. Well, there may be different scenarios, and there may be hypothetical questions, hypothetical situations, and so on. If we're talking about the change in the operator, there should be a tendering process. If what the legal advisor what said does happen, how would it what will transpire?
Thank you for the legal advisor's question. When it comes to an operating right change, what will happen? Actually, there are many scenarios possible. The law wants to cover all scenarios. That is, we have a mechanism in place. Should there be disputes, there should be negotiations, and the government may also intervene, etc. So there are all sorts of scenarios. Let me talk about the basic principle first, and see if the legal advisor would have further questions. Now, first of all, why does the government want to grant an operating right? Well, according to the bill, because we want the big tramway to continue to be an essential icon in Hong Kong. So when the CE in Council grants an operating right, it's stated very clearly. It says that the CE in Council would have to look at all relevant factors. And we have set out 5 scenarios. When the CE in Council decides to whom the operating rights will be granted, actually this is not an easy task, because it has to make sure that the tramway would continue to be a major leisure facility. So the most common way of doing this is to conduct a tendering exercise. After getting the tendering document, we will look at the conditions offered and we will compare these offers with the government's requirements, and then we will choose an awardee. And when it comes to the right to asset ownership, the new corporate operator may have to talk to the incumbent operator. So all these are allowed because when we consider granting the operating rights, we would know that the new operator does not have the right to the assets at that moment, and the new operator needs those assets. So we hope that we are allowing 3 years for transfer. For a new operator, a lot of things have to be done, so a 3-year period is a more practical time frame. For example, the negotiation may last for half a year, then we will ask the two parties whether there has been any progress, and if no progress has been made, then we will ask what happened, because the government has decided that there should be an operating rights transfer. So the only thing that has to be discussed is the conditions and terms, and it's not about whether the operating rights should be transferred. If the incumbent operator and the new operator cannot come to a consensus, then the CE Council may intervene. They may ask the incumbent operator to surrender its operating rights first, and then arbitration may follow. So within those 3 years, there may be all sorts of disputes, or there may be an voluntary exit, or the government may ask the incumbent operator to exit, or there can be a negotiation or tendering exercise. Well, we can take care of all sorts of scenarios. So ample opportunities would be given to all parties for discussions. Now the government is pretty sure that everything will be in order. Now it's time for members to raise questions. There will not be any time restriction. Well, Chairman, I would like to respond to the questions raised just now. Okay, Mr. Yik. Well, in general, now if I have an operating right, can I just ask my friend to take over the operating rights? That's not possible. The only thing is that I can sell my company. These kind of things have happened before. Well, would the service be disrupted? Well, this Deputy Secretary just now has mentioned a number of scenarios. Some are voluntary, some are involuntary. Well, the incumbent operator may have to look for interested parties in the market. For example, that happened to Hong Kong Tramway. There was no problem in operating rights transfer. But if the incumbent operator goes bankrupt, then the government may have to intervene. So this is what I want to say about the questions raised just now. Yes, I agree with Mr. Yik. There are many different scenarios and a lot of things may happen. However, the most important thing is that the bill covers a broad area, and if anything happens, things will not go out of hand. And the incumbent operator, no matter whether he exits or he's transferring his shares to other companies, there should be an adequate mechanism in place so that things will not go out of control, right? Any other questions? Mr. Yik? Now, I would like to talk about the government's latest amendment. So there are no questions concerning the legal advisors issues, right? Okay, then now the government has proposed some CSAs. We can look at them. Mr. Yik? Thank you, Chairman. The government has responded to our questions raised at the last meeting. I have read the paper. And for the protection of private properties, if we look at Article 105 in such a narrow manner, then I will still have reservation. Now, the government, now you are just protecting the second part, but how about my right and freedom to use the land? I think that's affected because now you have added new clauses. So I do not agree to that. And the Deputy Secretary explains that this is case specific because for all operating rights, when they are renewed, there would be a process of bargaining. So if these are added, if the operating rights holder agrees to this, then I cannot say anything. But what will happen if there's another operator? You cannot say that I can add these to all the ordinances which are about modes of transport. So I hope that the government will tell me that this will not set a precedent. Now, if the incumbent operator accepts this new provisions, then I would not argue. But I hope the government will tell me that this is not a precedent. Yes, you are right, Mr. Yik. We can assure you. And let me tell you more justifications. For this bill, its title is very clear. It's called a Peak Tramway Amendments Bill. Well, there is only one peak tramway in Hong Kong. After amending this bill, the ordinance will only be applicable to the peak tramway. So it doesn't mean that when this piece of legislation is approved by the LegCo, then this ordinance will also apply to other ordinances and other modes of transport. It will only be applicable to the peak tramway. And the most crucial thing is that whether we abide by the basic law. This is the fourth meeting, and in the last three meetings, we have explained in great details why and how have we been abiding by the basic law. As for the basic law stipulation, it doesn't mean that the government cannot appropriate private properties. The most important thing is that an appropriate compensation can be made. And a very important point is the market rate. So if everything is in order, then this can be done. And this is not about appropriation. We are just talking about lease. And a market rent would solve the problem. So it is not like the government taking over the piece of land. The title still belong to the original owners. So it's not like the government trying to get the rights of that piece of land. And as Mr. Yik says, now if the operator agrees to that, then it means that the property owner has already agreed on a lease with the government. So it is a contractual agreement. So why must we put it in the law? In the latest paper we provide to members, we explain in great details as to why this has to be done through legislation. Now we are talking about a Hong Kong icon. The Peak Tramway has been in existence in Hong Kong for over 100 years. So we are not just talking about the relationship between the government and the existing operator. We hope that this bill can take care of different operators. So if the incumbent operator wants to sell the land, so will the new operator have to abide by the same requirements? Our paper has explained about this. Now, under the common law, this is not clear. So we do not want the new operator to argue with the government all the time. Otherwise, this peak tram service will be disrupted. So we have to handle this with legal provisions, and this is the most pragmatic solution. So that's why we have to use legislation, and this piece of legislation will not affect other ordinances. So this is a very unique case. Different modes of transport have their own operating rights. So you would look at these applications on a case-by-case basis, right? Yes. So Mr. Yik, are you happy with the answer? Thank you for the explanation. Well, I still do not see eye to eye with you in some areas. However, as the incumbent operator has accepted these arrangements and you say that this is not a precedent, then I can accept it for the moment. Dr. Chen Kalop. Now, with regard to this bill, I understand that there is a time constraint. If we do not come up with a better idea to handle this transitional period, and there may be more problems. I understand that there are still some areas where improvements can be made. However, we are under the pressure of time. That's the same for the peak tramway as well as the electrical. Chairman, has there been a public consultation concerning this issue? Some of my assistants have conducted a study that is under the existing Hong Kong law. What is meant by public engagement? Now, I think nowadays public consultation is very important. It's common sense. We only have one peak tramway in Hong Kong.
So we are not just looking at whether the company is sound financially. In the course of the discussions, we found that there are other issues that need to be tackled. Well, maybe it's difficult to make public sensitive information of the company. There may be issues related to conservation, the design of the tram cars, and so on. All these issues can be involved in the granting of the operating right of tramway. Can the government consider building in public inspections and public participation elements in the ordinance? Well, you have control of the public purse, and I can't raise any points in relation to the public expenditure. Well, you don't think there is a need to build in the points that I mentioned. But if we go to the second reading debate, I would like you to clarify this. You said that all along you've been consulting the public, but you sounded very vague. To the electrical and the district councils, we hope that you can consult us more in depth. There would be more focused discussions so that our views can be considered in your decisions. So can you give us an undertaking and that is even if I can't move any CSAs, because the government doesn't deal with the kind of CSAs that I mentioned. Can you give an undertaking? Yes, Andy. Thank you, Dr. Chen, for your very well-intentioned remarks and your very useful suggestion. In the meeting before the last, Dr. Chen raised the same question. Perhaps I haven't been able to give a very detailed reply then. Now, when this EXCO decided on whether to grant a new operating right, it has to take into account a number of relevant factors. There are 5 factors listed in the bill, but the factors are not restricted to these 5 only. And how can public opinion be built into the whole decision-making process? I can tell you for sure that EXCO will take heed of public opinion in making its decision. Now, how can that be done through our procedures? I will be giving you a reply verbally now, and then I would also be giving you a reply in writing later on. Now, since the EXCO makes a decision on granting the operating right, the administration must give the EXCO a paper on what applications have been received and its assessment on the various applications, and recommendation will be made. Now, before a decision is made, we would definitely come back to the LegCo to consult you on whether the way forward proposed is appropriate. And that is something that we'll do before our proposal gets to EXCO. Now, after we've heard your views, we will reflect your views to the EXCO in our policy paper. So in terms of our administrative procedures, where public opinion would definitely be factored in, and decisions will be made based also on public opinion. This is the established practice, and that's what we've done in past granting of operating rights, and we will do the same in the future. Well, to make this a solemn undertaking, we are happy that after this Bills Committee has scrutinized the bill, when we submit the bill for the second reading debate and the third reading, Professor Zhang will explain all the policy considerations. He will have a speech to be delivered, and we are more than happy to put in that speech what I said, and that is how EXCO will consider public opinion in its decision. All the procedures will be set out in that speech. Well, I welcome that kind of reply, and I also ask that in the second reading debate, the Secretary can further elaborate on how public views, and not just the views of the LegCo, can be effectively gauged and reflected to the EXCO for it to come up with its decision, and also how the EXCO will view the various public opinions. And Mr. Chan, you should also give sufficient time for the public to discuss the issue. You now have a 10+10 arrangement. Well, the Peak Tramway Company has made a lot of undertakings to us, and he said that after the right has been renewed, they will embark on a series of improvement measures. And when these improvement measures are submitted to the administration, how will the administration discuss these proposals with the district councils and the LegCo and the public, so that the latter can discuss the proposals fully? And if there are different views expressed, they will be thoroughly considered by the EXCO in its decision on the 10+10 application. What I'm most worried that you will just make a decision after we have our discussions here at the Bills Committee. So that's why I want you to explain clearly how you would deal with public opinion. And also, in the second reading debate, the Secretary should also thresh out all the public opinions gathered and then elaborate on those in a speech to the full sitting. Let me add here, as I said, every time when we grant new operating right to the tramway, we will consult the Legislative Council. This will continue, of course. And what we have to deal with now is 10+10 application. And first, we would have to decide on whether we would grant an operating right of 10 years to the Peak Tramway Company. And through consultation at the Economic Development Panel and also the discussions at 4 meetings of the Bills Committee, the government has been discussing our inclination towards the 10-year application. Now, after that, if the administration has received the extra 10-year application proposal from the PTC, and we suppose there will be detailed proposals there, then we would also forward these proposals to the LegCo for your consideration, and then we will also reflect your views to the Peak Tramway Company, PTC. And we can undertake that if we are to grant a 10+10 extension right to the PTC, we will consult the LegCo. I think we've already done the consultation on the first 10-year application. I think you have come up with a clearer answer than you did last time. You would be submitting the improvement proposals to the LegCo for us to consider and consult us, right? Yes. Mr. Sin Chung Kai. I made a suggestion, and I asked that that the EXCO should consider the application within a certain period, a specific number of the years be given. But then here you are proposing without unreasonable delay. With the addition of that proposed provision, I believe that the government should deal with the application speedily, without delay. I don't expect, say, the government would take, say, 3 to 4 years to consider the application. So at this stage, I accept your proposed amendment. I will not move any CSA myself. I think the government should abide by this spirit of this provision when you actually implement the amendment law. Mr. Frankie Yik, I would like to respond to what Mr. Chan raised. When the government considers regranting the franchise or the operating right, my experience is that they will tighten the terms of the license if there are public views which said so. Mr. Chen Kam-lam. We agree with the proposed CSAs in principle. They are dealing with a private property, and at the same time they have to come with future arrangements for the operation of the tramway. There can not be a perfect solution. You can't resume the land when the operating right expires, and you can't come up with a perfect solution. This arrangement can only be put in place, a proper arrangement can only be put in place under the supervision of the government. The Peak Tramway has undertaken to further improve its service and make heavier investment. And as a business organization, of course, it helps that the operating right can last longer. And if the administration wants to extend it to for a further 10 years, I think that's also acceptable. I hope that the operator and the administration can liaise closely in the future. It's impossible for us to build another tramway beside the existing one, and there is no competition to talk of here for this service. So we really count on the incumbent operator to provide the best service. So 10 plus 10 is acceptable, and if they don't do their job properly, perhaps we'll just have to leave it to our next generation to come up with a smarter way of dealing with the operating right. So for me, I think this, all these proposed CSAs and the bill should be acceptable. Any further question? So if not, then I would ask members, do you accept the CSAs proposed by the administration? If we are all agreed. Well, in fact, in the last meeting, we've finished the clause-by-clause scrutiny. And I would like to ask the administration, when will the second reading debate be resumed? Do you have a timetable? Because we have to submit our report to the House Committee. We'll try to strive to submit the bill to the full council ASAP and finish with the work as soon as possible. The first regular meeting after the summer recess will be our ideal date. That would be the end of October. The Bills Committee will submit a report to the House Committee before that to report on the deliberations of the Bills Committee. I would also like to inform members that the legislative timetable for 2015 and 16 has not yet been compiled. And once we've received that timetable, and we will work together with the government, and we will let members know when we will submit our report to the House Committee, and also come up with the date, the deadline for giving notice for moving CSAs. If there is no further question, I think we are finished with our work at the Bills Committee, and I would like to ask the Secretary to finish all the other preparatory work. Thank you very much, and all the best wishes for a summer holiday. Meeting adjourned.